technology that is built for your every sense. Acer Pure from Acer.
Big development that has now happened in the Supreme Court, declining to stay the Waqf Amendment Act in its entirety, observing that there is no case that has been made out for such a sweeping order, though it has noted that certain provisions may require interim protection and stay that has been granted to certain provisions. How both sides are reacting, both sides claiming vindication, welcoming it, calling it as a balanced interim verdict that has been announced by the court. Harish is with us. Harish is getting us multiple reactions that are coming in from both sides, how they are reacting to this judgment. Over to you, Harish.
Yes, that's right, Amita. In fact, both sides, in fact, it is being touted as a win-win interim order. Both sides are, in fact, claiming victory. I have with me
the conversation. We are getting political reactions
regarding this verdict which has been given by the Supreme Court today regarding the Waqf Amendment Act.
See, I can respond only to what we have heard in the pronouncement that was made. The Chief Justice clarified a few things, but the judgment has not been uploaded, so the fine point would not be possible to comment on. That one can only do once the judgment is uploaded. But I think the broad concern that people had about this legislation, the amendment legislation, it appears that the broad concern has been addressed squarely by the court. The court clearly said that we can't stay the entire act. Yes. Understandable, because it's not done in law that you stay an entire act, etc. Perhaps it wasn't even necessary. But the provisions that were a major concern for people, those provisions have been addressed and addressed rather well. One point was who can declare a waqf, who can dedicate a waqf. And they said it had to be a person who was practicing Muslim for 5 years and so on and so forth. That has been stayed for all practical purposes, saying that unless it is made clear by rules, this would be arbitrary. So that's been stayed. So that's not an issue anymore for the present. The second thing that was said was that, if somebody said this is not Waqf property, this is government property, if there's a contest, and often there is a contest between government property and Waqf property, then the collector could decide. And it could just be the ipse dixit of the collector saying this is government property. And the Waqf would have to give up and say that fine, good, we have no other option. Now they've said this can't be done in this manner. This has to be done under the genuine procedure that is provided, that you go to the tribunal, you go to High Court, and finally when it's decided, only then can the collector say these changes should be made. So I think that's a very important matter of relief that's been given. Then there was at the end, one of the senior counsel said, the registration issue you're upholding, because he said you've always required registration, so why should you question the registration now? So we have upheld the registration for the present. And they said, but then, the timeline has run out. At that time, whatever the time was given, 6 months, etc. So the judges said, we've addressed this in the judgment, we've addressed this, we've taken care of it. So I would imagine that everything that concerned people has figured. But the finer points, if at all there are finer points, we can only comment on once the judgment is available.
Okay. But sir, do you believe that this is a victory of the opposition as well? Because you have been continuously raising this concern regarding these amendments which are being brought in by the central government, whether it is about the clause related to the waqf by user or the inclusion of the non-Muslim people in this committee. All of these points are also being covered in this verdict.
Of course, it's being covered. The balance of the Central Waqf Council and the Waqf boards, that balance has been maintained. There are people, and there were people even before, from beyond the community. Right now, if you have public representatives who are not from the community, but they can provide good inputs, etc. So to that extent, they can be included. And this court has said that the balance must be maintained, that the majority must be from the community, but a balance can be maintained inputs to be provided by people outside the community. That has been said. And they've also said that when it comes to appointing the chief executive officer, we are not actually dictating anything on it, but we expect and hope that the best efforts will be made to find the chief executive officer from the community, etc. So I think it's an extreme balance. We shouldn't talk about victory and defeat. Nobody wins and nobody loses, because this is in the interest of everybody. It can't be that this was only for the benefit of exclusively people from the religion of Islam. This is for Indian citizens, and Indian citizens being looked after, whether you are a Hindu or a Muslim or a Christian or a Sikh. Whatever are your institutions that are recognized for decades as your important institutions, like, you have the Gurudwaras and you have the Gurudwara Samitis. Similarly, you have the temple trusts, etc., and you have the church properties. So the institutions need to be protected, because they've been protected for a long time and they're part of the existence of that community. So I don't think it's really a win-win situation. It's not a win and a lose situation.
Okay. But sir, we have seen that when this bill wasn't brought in the parliament, at that point in time, the government used to say that this is being done only to bring transparency in this entire, in this entire matter. The manner in which the land has been occupied by Waqf, there are many of the people who used to complain about it, and that is the only reason why these kind of amendments are being introduced by the central government.
Well, there you are. The court has very clearly said, we want transparency. But we, meaning the judiciary, the tribunals and the judiciary, must have the last word. You can't leave it to officials. You can't leave it to executive. You can't leave it to the government. They have a point of view. Their point of view will be heard. As the point of view of the government side or the establishment side is always heard in any court of law or any tribunal, it will continue to be heard, and the weight that should be given to it will continue to be given. That's not a problem at all.
So calling it as a balanced approach, that is Salman Khurshid, multiple as far as when it comes to petitions that were taken up in the court, which the Supreme Court for now has decided to refuse to put a stay on the entire Waqf Amendment Act, but however has put a partial stay on certain provisions, on certain clauses. But let's get back as far as to Harish in this case is concerned. Harish, when we talk about these developments that are now coming at a time, mainly, as we heard Salman Khurshid calling it, that it is a win-win situation for both sides. Transparency seems to be the main case, and also reiterating when it comes to the law is now concerned, the constitutionality and the blanket states are only rarest of rare, as pointed out by the Supreme Court.
Yes, that's right, Amita. The Supreme Court Chief Justice, in fact, saying that there is a presumption of constitutionality as far as a law passed by the Parliament is concerned. But the Muslim side basically saying that it's a victory for them because key provisions of the Waqf Act has been stayed by the Supreme Court. I'm joined by Advocate Anas Tanveer, who had appeared for two Muslim parties in this matter. Let us know from him what are the key provisions in this Waqf Act which has been stayed by the Supreme Court. Mr. Tanveer.
So in the interim order, the court has stayed the provision that said that you have to be a practicing Muslim for 5 years to create Waqf.
Yeah.
The second one, that wherever the collector thought there was a dispute and the Waqf would cease to be a Waqf, that has been stayed until the High Court gives a determination on that. And until then, no property can be denotified or dispossessed. On the non-Muslim members, the court has fixed the limit that there cannot be more than 3 in the Waqf board or 4 in the Waqf council. As far as chief executive officer is concerned, the court has said that while they are not staying the provision, the effort should be made to ensure that a Muslim officer is made the
So in a way, the Supreme Court has rejected, for the time being, the plea of the petitioners that there cannot be a non-Muslim in the State Waqf Board or Central Waqf Council.
See, our argument was that it is lopsided and the majority comes to the non-Muslims. So the court has put an embargo on it, has put a upper limit on that. And I will not say that the court has not considered that. Court has considered that. That is why we are saying it's a very balanced order. We, from what has been pronounced orally, will read the judgment. We have no quarrel. We accept this. It is a good order for us.
So according to what has gone in favor of the centre?
See, nothing has gone in the favor of centre because it is their law and the presumption is in their favor, and despite that presumption, if the provisions have been stayed, that means that there is a prima facie case that the Act and certain provisions may be completely unconstitutional.
The court has said registration of Waqf properties should continue.
Yes, and that is on the basis of the fact that the registration was mandated in the previous Act as well. It is not a new thing. It is only on the punishment aspect, the penalty aspect, that we will have to see what the court has said. But when Mr. C.U. Singh mentioned that, the court said that we have extended the timeline. Again, we'll have to read the judgment conclusively comment on that.
The court has said collector cannot be given overriding powers on that.
Yes, and rightly so. The executive cannot take the judicial powers. And now that they cannot dispossess, and because earlier the fear was that any person could raise a dispute and the property would cease to be a Waqf property. That has been stopped. So, and the determination is not just until by the Waqf tribunal, but also by the High Court. And High Court is a constitutional court. So we are hoping that the justice will be done. And even this embargo that the court has put, even though without staying it completely, is a victory for us.
So for the time being, the power rests with the tribunal and the High Court.
Yes, first the tribunal and then appeal.
But that's the better understanding that Harish is getting for us as far as on these three provisions there, the stay that has been granted, not to the entire statute altogether, but collector's role here, Harish, is continuing to be with us as even when we have Bhavtosh joining in. Bhavtosh, that point in time, the centre had defended the Act, saying that the Waqf was a secular concept and its very nature that it could not be given a stay given the presumption of constitutionality in its favour, while it was saying that as far as when it comes to the DM is concerned, or the collector in this case is concerned, should be given that powers.
Yes, in fact, that issue, which is also had in fact led many of the petitioners, including opposition leaders and also some Muslim leaders, to come to the Supreme Court, has been stayed, which is the excessive powers to collector that has been stayed. In fact, we are joined by one of the lawyers who in fact argued in the Supreme Court, Ashwini Upadhyay. This was a contentious issue of the powers to collectors and to bureaucrats and district magistrate. Has this power has been stayed, or we have to wait till the final order of the Supreme Court?
कुल नए वाले कानून के 12 प्रोविजंस को सुप्रीम कोर्ट में चैलेंज किया गया था और 12 प्रोविजंस पे स्टे लगाने की मांग की गई थी। माननीय सुप्रीम कोर्ट ने उसमें से एक प्रोविजन पे स्टे किया है, बाकी 11 प्रोविजंस पे स्टे लगाने से मना कर दिया है। वो एक प्रोविजन ये है 5 ईयर प्रैक्टिसिंग इस्लाम। नए वाले कानून में ये व्यवस्था है कि जो डिक्लेयर करेगा कि आज मैं कन्वर्ट हुआ और पिछले मैं 5 साल से प्रैक्टिस कर रहा हूं इस्लाम, वही वक्फ कर पाएगा। कोई ऐसा नहीं होगा कि हाँ आज कन्वर्ट हुआ और कल ही वो वक्फ कर दे। तो उस पर माननीय सुप्रीम कोर्ट ने रोक लगाया है। बाकी और जो प्रोविजंस हैं उस पर कोई स्टे नहीं है। जैसे पहले वाले कानून के अंतर्गत डिस्प्यूट शुरू हो चुके थे ट्रिब्यूनल में, वो ट्रिब्यूनल में चलते रहेंगे, उनमें कोई रोक नहीं लगाई है। वक्फ बाई यूजर को पहले जो कॉन्सेप्ट था उसको इसमें खत्म किया गया। इसमें वक्फ बाई ओनर का कॉन्सेप्ट लाया गया कि जमीन वही वक्फ कर पाएगा जो उसकी ओनर होगा। यानी पहले आपको ओनरशिप प्रूव करना पड़ेगा। पहले तो आपको यूजर आपको प्रूव करना था कि हाँ मैं इसको यूज कर रहा हूं, मैं वक्फ कर सकता हूं। नए वाले में कहा नहीं, पहले आपको ओनरशिप प्रूव करना है कि वो जमीन आपकी है। तो उस पर भी माननीय सुप्रीम कोर्ट ने कोई रोक नहीं लगाई है। कलेक्टर के अधिकारों की बात यह है कि कलेक्टर के अधिकारों में एक थोड़ी सी क्लैरिटी की कमी थी। माननीय सुप्रीम कोर्ट ने उसको स्पष्ट कर दिया है कि कलेक्टर के पास जो अधिकार थे देखने का कि वो जमीन का मालिकाना हक किसका है, वो तो देख सकते हैं, लेकिन कलेक्टर का जो ऑर्डर होगा वो फाइनल नहीं होगा, उसको भी अपील किया जा सकता है। वो उस पर क्लेरिफिकेशन आया। तो कलेक्टर के जो जजमेंट होते हैं वो तो पहले भी अपील होते रहे। मतलब नॉर्मल सिविल प्रोसीजर कोड में भी जो जमीन का विवाद होता है वो एडीएम डिसाइड करते हैं या तहसीलदार डिसाइड करते हैं या कलेक्टर डिसाइड करते हैं। तो उसके लिए भी एक व्यवस्था होती है। चकबंदी कमिश्नर के यहाँ लोग जाते हैं, यहाँ उसको कहा गया कि नहीं आप उसको ट्रिब्यूनल में भी चैलेंज कर सकते हैं। एक वो क्लैरिटी है। बाकी मेरा ये मानना है कि जो नया वाला कानून है वो 99.99% एक तरीके से इफेक्ट में है, उसमें कोई रोक नहीं लगेगी।
That was Ashwani Upadhyay. He says that 99% of the Waqf Amendment Act will stay till the final order is given. He says that as far as the issue of the powers of collector is concerned, anyway, if anyone wants to challenge it, it used to go to the civil court. But having said that,
as far as when it comes to the tribunal, and even when it comes to the decision, if taken by the collector, it can be challenged. That is what Ashwani Upadhyay is saying, that this is a clarification that has been given by the court in this case. But political reactions that have been coming in, remember, it was a mix of political parties and other petitioners as well, which had challenged the Waqf Amendment Act in the Supreme Court. As far as these petitions that are concerned, today is the day an interim order that has now been given out by the Supreme Court as we are awaiting for the detailed copy of the judgment. Let's listen into those reactions.
एक बड़ी राहत है ये, बड़ी जीत है ये, और कुछ पॉइंट्स तो बहुत महत्वपूर्ण थे और इस अमेंडमेंट को बहुत खतरनाक बना रहे थे, उस पर रोक लगाया है माननीय उच्चतम न्यायालय ने। तो मैं इसे जीत के तौर पे देखूंगा। कलेक्टर राज वाला जो पॉइंट है उस पर रोक लगाना, प्रैक्टिसिंग मुस्लिम पे सवाल खड़े कर देना और उस पे रोक लगा देना, मुझे लगता है ये दो तो बहुत ही महत्वपूर्ण पॉइंट है।
So one of the contentious issue was of a person to be a practicing Muslim before he or she can create a waqf. Do you think the stay that has been put by the Supreme Court is in the right direction?
नहीं, 100% पूछा है माननीय उच्चतम न्यायालय ने कि आप रूल तो फ्रेम करो, कैसे डिसाइड करोगे कि हु इज द प्रैक्टिसिंग मुस्लिम और नॉट, हु इज द प्रैक्टिसिंग हिंदू और नॉट, कैसे डिसाइड करोगे आप? तो वो डिसाइड करने का पहले मसौदा तो लेके आओ, तो इट्स गुड। मुझे लगता है कि अच्छा।
The other point that has been stated by the Supreme Court is about the bureaucrats, too much interference.
डे वन से हम सारे लोग कह रहे हैं कि कलेक्टर के जरिए जमीनों को लूटने की कोशिश है। माननीय उच्चतम न्यायालय ने रोक लगा दिया। धन्यवाद।
The other one is about the representation in the waqf from
अब उस जजमेंट को पूरा पढ़ने के बाद कुछ उस पर हम बोल पाएंगे, लेकिन जो इनिशियली हमारे पास इंफॉर्मेशन है उसके हिसाब से ये वक्फ की लड़ाई लड़ने वालों की जीत है।
So both sides claiming that the interim judgment has gone in their favor. But Harish, for a better understanding, when the Chief Justice was pronouncing the interim order, the three key issues, including the power to denotify properties declared by Waqf by courts, Waqf by user or Waqf by deed, that has also cropped up during the hearing of the pleas challenging the Waqf Amendment Act.
Yes, that's right, Amita. In fact, during the hearing, just to try and prevent a stay by the Supreme Court, the Solicitor General Tushar Mehta, who had appeared for the centre, had given three assurances just when the Supreme Court had threatened to stay the act. Number one, the government assured that till further orders, no Waqf by registration, Waqf by user or Waqf by notification will be denotified. That is number one. Number two, the government assured that till further orders, all disputes being examined by the collector will continue to be a Waqf property as against in the Waqf Act. Number three, most important, the government had assured the Supreme Court that till further orders, no appointment will be made regarding, as far as non-Muslims are concerned, to the state Waqf board or central.
The Supreme Court today has refused to stay the entire Waqf Amendment Act, but put as a partial stay on certain clauses, where the top court has reiterated that the laws of parliament enjoy a presumption of constitutionality and blanket stays are only rarest of rare. Thank you very much for the moment, Bhavtosh and Harish, for